All right, there's an awful lot of advantage to having a lifetime of protection, but is it worth it? Hi, Jeff Versace, the Plain English Attorney, and we've got a very interesting question that we're kind of reacting to from r/estate planning in the Reddit threads. This one is about two children inheriting a house through a trust, and the brother's making a suggestion to just open accounts in the name of the trust, but one for each of them. Let's go ahead and jump into it and see exactly what's going on and what the answer to the question can or should be. All right, selling the house in a trust. My brother and I are preparing to sell our mom's house after she passed away. The house was in a trust, and my brother and I are 50-50 beneficiaries. Since we are selling it in our mom's trust, and our mom did not have a bank account open in the name of her trust, we were told we need to open a bank account in the name of our mom's trust in order to receive the funds. We have now done this. From there, I figured that the money would be distributed into our regular bank accounts. However, my brother is saying that instead, we should open two separate trust bank accounts in our names in order to protect/shield the money. He says that we do not need to actually have a trust lawyer create new trusts for us. We simply need to have our trust lawyer create a document stating that my brother and I are 50-50 beneficiaries of our mom's trust, and the bank will then open up trust bank accounts in our names, and the funds will be distributed into those two accounts. And as long as the money stays in those two new trust bank accounts, the funds are then shielded against lawsuits, divorce, etc., as long as the funds stay in those accounts. Is that correct? I guess my main questions are, one, is it possible to open the trust bank account in my brother and my names without actually having trust created through a trust lawyer? And also, two, is there any advantage to that at all? All right, there's an awful lot of advantage to having a lifetime of protection, but is it worth it? If what we're talking about here, and this is a concept that a lot of people aren't getting, and it's not clicking with them, you don't have to have one document per trust. You can have like a revocable living trust. It says, here's how everything is run. And if we have a, quote, subtrust that's created, it's a separate trust. You don't need to run and do a separate document because the language is already in there. So that takes care of that first overall thing. Can we do this? They need to check and make sure that the trust document that mom had allows for that. And then what are the terms for those, quote, ongoing trusts? It very well could have that additional protection. Let's talk about just a couple of the cons. Well, now you're talking about two different subtrusts. They're going to need a taxpayer ID number. They're going to need to file trust tax returns, and this is going to be an ongoing thing for them tax-wise each and every year. And, well, who's the trustee? If it's not the one, they can't be the trust overseeing their own trust as the trustee and expect to get that kind of protection. So that's also something to take a look at. Who's the trustee? Is this going to make sense? Now, sometimes we very clearly put together trusts where a person who's going to be protected, they are not the trustee. They can't be the trustee. There are prohibitions against them becoming the trustee. But usually this is something where if they really, really, really want to provide that protection for the next generation, they're going to use something like a beneficiary trust or an asset management trust. And we've got other videos for that in the playlists and coming up. So that's one consideration. It's the ongoing tax return. Can you be the trustee? If you're the trustee of your own trust and you have discretion to distribute the money, you don't get that protection. Let's read a little bit. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Further and see what else we got here. First response: unless the house is the only asset in trust, just open a trust account so you can make distributions. You're overthinking this. That can get to be confusing, especially since it's, all right, they're 50-50 beneficiaries. Well, they can put that money into one account. And when they have that one account and they make distributions out, well, now you have to account for everything. If they were going to like turn this into a rental property or something and they just distribute the profits equally each year, well, that's fine. Well, if one brother needs money and the other doesn't, it becomes an accounting nightmare. It's, well, he took $20,000 out. Well, yeah, but we had this much profit. He took that out a year ago, and we've got this much profit over the year. Well, wait a minute. He has $20,000 less in profit. So what's the proportion? And let's start doing the math. It just becomes an accounting nightmare. So I don't typically recommend that you, going into the next generation, that you just take whatever the beneficiaries have and put it into one account. I once had a financial advisor where we had two people. It was separate property. They kind of had their own investment accounts, and he convinced them to merge them in the name of their joint trust, even though they wanted to keep it separate, because the fees would be lower with the higher amount for both of them. For years, it was this big accounting nightmare. They took this much money out, and well, they wanted this investments and this. Oh my God, it was not worth the savings in the brokerage fees that they saved just to do all the accounting around it. It's always better ongoing to have it be separate. All right, so let's check out a little more. Yes, the house is the only asset in the trust, and my brother is making me feel like I am an idiot for not transferring the money from our mom's trust bank account and directly into new trust bank accounts in each of our names in order to shield us from a lawsuit we might face if we were to get into an accident or something and someone sues either of us for millions of dollars. Not very likely to happen, but he's just using that scenario as an example. He says the money can't be touched if it goes into a trust bank account in our names after it gets deposited into our mom's trust bank account after the house is sold. Well, okay, we already talked a little bit about that. If the trust continues as an asset protection trust, that's correct. But if it mandates a distribution, that is not correct. Honestly, it's not really worth fighting over just a house, even if it's $1 million house. It'd be what I personally consider an uneconomic trust. Just go along with it and get your money and move on. The alternative is to get a lawyer to review everything, but really your brother should consult an attorney to get some actual answers to his questions. It sounds like the brother may have gotten some advice from a non-attorney. Oh, wait, you're selling that house and it's in your mom's trust? Oh, you can get all this protection if you leave it in the trust, but you can do it in two separate bank accounts. And he's running with that instead of getting the pros and cons from the attorney. So it's true. If that document has ongoing asset protection features, you can do this. In fact, that's kind of what mom intended, but we don't know. Right. Not necessarily, unless there are some provisions for a testamentary trust slash spendthrift provisions within your mother's trust. Creditors versus divorce are very different as well. And that is very true. Uh, Again, if they are the trustees, it's kind of hard to say, well, you're the trustee, you're the beneficiary, you can give yourself money anytime you want. How protective is this trust really if there isn't at least a co-trustee that has to end up approving these distributions, and there's not a way to remove you in case of a lawsuit? Yeah, that very well could come off the table. Plus, in divorce, there's definitely a lot less creditor protection. Again, if you've got access to that, well, all right, you kept it separate. It doesn't matter because largely, I'm only going to say that, largely inherited assets that remain separate end up not being on the table for divorce. So it's the divorce issue. You may already have protection if you keep it separate, or at least some. But when you're talking about creditors, anything may be able to go if you're the trustee. All right. My question is it possible to open a trust bank accounts in my brother and my names without actually having trust created through a trust lawyer? And also, too, is there any advantage to that at all? Yes, yes. As we talked about earlier, that can have a lot of protection. Yes, you can do it. And it's, again, that one principle that seems to evade a lot of people because it's not really explained well by the legal community. The trust document can have the language to create multiple trusts. The bank is going to want a certificate of trust or the actual trust document which creates the trust, or they might not. You can always create a constructive trust. It prevents fighting with your brother over something that is quite frankly pointless to fight about. And they've got a good point. It's like, look, if your brother wants to do this and you've got control over your share, go ahead, do it. And then just take your money out and do what you want to do with it anyway. Will you lose protection? Well, you could, but there's a lot more information needed. So I hope you found that information useful. Hope it's generating some questions. If you're thinking about putting together your planning in a way that protects the next generation, make it very, very, very clear. Check out some of the other videos on like beneficiary trusts, IRA trusts, asset management trusts, and in particular, the in-law planning course that I put together in the inlawplanningwebinar.com. That's got a webinar that's free. That's going to give you some more ideas and information on how you can plan to make sure that your kids aren't fighting over this, because it's made very clear. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.